So we have an important update in a critical rifle and magazine ban challenge. The Trump administration recently stepped up, and they also just participated in oral arguments at the 7th Circuit level, and they argued against states outright banning rifles and magazines. So this is big news. It was a huge oral argument. So let's break down what just happened. Now, before we jump into the video, I want to mention once again that right now I have my legal course available to you guys. I know a lot of you signed up for the free legal guide and you found a lot of value in that. And one of the things coming out of that is a lot of people are asking for more information, more in-depth like templates, videos, discussions about some variety of topics, two-way topics, self-defense topics. So we created a course for you. Right now, we only have about 48 hours left, probably less than that at this point. And so if you're interested, if you want to sign up for that, you can check it out using the links down below in the details section, also in the pinned comment. It's only going to be open for a period of time. It's actually going to end Friday at midnight. So tomorrow night on Friday, it's going to close. And then we're not going to have it open up anymore. And really what the whole goal with that is to have people in the course that we can pay attention to, give focus to, and help them along with any questions that they might have. So if you're interested, once again, time's running out. You can find that legal course linked down below in the details section, also in the pinned comment. Again, thank you to everybody who signed up. And again, if you're interested, check those links out down below. Now, as I mentioned in the intro, we have some great news in a critical case challenging the state of Illinois' ban on so-called assault weapons and also their magazine restrictions. The Trump administration, along with various 2A organizations, just argued in the 7th Circuit against that state ban on rifles and magazines in the state of Illinois. Currently, the state of Illinois, again, is asking for the 7th Circuit to reverse what happened in the lower court. In the lower court, Judge McGlynn issued a final merits decision. It was a pro-2A decision striking down this state rifle ban and magazine ban. The Trump administration, along with the plaintiffs, argued during those oral arguments that Judge McGlynn's decision should actually stand and that the 7th Circuit should find that these rifle and magazines are constitutional and they cannot be outright restricted. This is great news and an important move by the administration to end the rifles and magazine bans nationwide and go after states that are putting in place these restrictions. So we need to talk about what happened during these oral arguments and how I think maybe the 7th Circuit is going to rule and where this goes from here. Now, you might remember that originally in multiple cases, because now these are multiple cases that have been consolidated at the 7th Circuit level, there were district courts that issued preliminary injunctions that were intended to halt the enforcement of PICA initially. However, the state of Illinois appealed those preliminary injunctions to the 7th Circuit, who upheld the ban, which then led multiple cases to seek immediate emergency Supreme Court intervention. But at that time, the Supreme Court denied emergency review to those cases, so it denied review to all those Illinois challenges. Now, while all of that was happening, there were some cases going on at the lower court level in front of Judge McGlynn, and he decided to reach a final merit determination. So he held a multi-day trial, a long evidentiary hearing on these cases, and then issued his final decision, again striking down PICA entirely. And like I mentioned, all of this has now come to a head because during oral arguments in the 7th Circuit, we got to see how these arguments played out. Now, if you want a general impression of the arguments and what I think, probably is going to be the outcome of this, I think this could be a 2-1 decision upholding McGlynn's decision. But I think if we get that win, that 2-1 win in our favor, it's going to be limited in scope. It seems like maybe some of the judges here on the 7th Circuit panel are potentially going to try to tailor this ruling and this decision to just apply to the plaintiffs here in this case, so just the named plaintiffs. And then also they'll potentially try to limit it in scope to where they're only going to say the AR-15 ban and the magazine ban are unconstitutional. Now, during the arguments, the state of Illinois claimed that there were issues with the whole findings of facts that were developed at the lower court level by Judge McGlynn and, which were used for his ruling. However, 2 of the 7th Circuit judges kind of pushed back against that and said that, isn't that exactly what the lower court was supposed to do? That's what they were directed to do. That's what they told Judge McGlynn to do, is develop the factual record and rule based on that record. One of the judges also mentioned to the state of Illinois in the questioning that Judge McGlynn wrote a 150-page, comprehensive opinion, and it's hard essentially to buy the argument that he didn't weigh all the evidence, that he didn't look at relevant evidence when he had that comprehensive of an opinion, and also held a multi-day trial with a lot of evidence that was submitted to him. So how could you say that he ignored some of the evidence? Despite all of that, Illinois still argued that the 7th Circuit should reverse Judge McGlynn because he issued what they claim is a clearly erroneous opinion and that he ignored some of the facts that were developed at the lower court level. But the appeals court seemed concerned that the state here, that Illinois, was simply asking them to reweigh evidence and look at the evidence on their own and issue a completely new decision, which they're not called to do on appeal. Now, in closing, the state of Illinois also brought up kind of the more nuanced approach and something that has now developed in response to Bruen and also Rahimi. The nuanced approach is kind of the anti-gun state's favorite arguments right now, because it's a way for them to deploy essentially this public interest weighing that was already rejected in Bruen. So they argue that the nuanced approach should be used in their favor because these rifles and magazines are so harmful to the public, they cause so many casualties, and therefore it's in the public's best interest to ban these items. Now, in response to that, the judges essentially said that the phrase nuanced approach and that analysis is not actually expressly mentioned in Rahimi, so why should they have to follow that? And the same judge also said that there was violence during the founding and there was, violence after. And just because technology has changed, that doesn't mean that you just simply change the analysis in the approach and deploy something like the nuanced approach. Now, one concerning thing that I did mention already is that one of the judges brings up how the lower court opinion was only focused on AR-15s and magazines. And what I think they're going to do here and what they're hinting at is that they're going to limit any positive ruling. So if we get a positive ruling, they're going to try to limit it to just those items, just AR-15s and just magazines, similar to what we saw a district court recently do in the Cheeseman case, I believe, out of New York. They tried to do the same thing, saying, a lot of the arguments down below were focused exclusively on AR-15s and magazines, and therefore they're only going to rule on that and not address any of the other firearms that are banned under the law there, which was PICA, because PICA touches not just AR-15s, it touches all semi-automatic rifles. It impacts some handguns, it impacts some shotguns and other items as well. But the arguments were so focused on AR-15s because obviously it's the most popular. It's kind of the one that the anti-gunners like to go after the most and argue against the most. So that's why a lot of the arguments were focused on that. But now the court here is hinting at they want to use that fact to essentially limit this decision and limit what Judge McGlynn said down below. Now, when it came time for the plaintiffs to argue in their favor, there was a question about, the registration requirement in the state of Illinois under PICA. The judges wanted to know if it's severable from the rifle ban. Essentially, could you still deploy and use the registration process even if the rifle ban is struck down? And the answer to that was no, because the registration is only in place and was only in the law to essentially track any grandfathered rifles. Essentially, the purpose would fall apart and no longer serve, its express purpose of tracking those grandfathered, rifles if the state ban generally is struck down. If these items are no longer banned, then why do you need a registration process? Also, during this segment of arguments, you had Judge Easterbrook, who is a horrible anti-gun judge. He brings up the issue of universal injunctions under the Trump versus Casa decision by the Supreme Court. He claims that this looks like a universal injunction, so why should they not reverse based on this being a universal injunction that was issued by the lower court? Now, the response to that by the plaintiff's attorneys was they're completely fine if the Seventh Circuit here wants to limit the relief to only apply to the named plaintiffs. And essentially they said, go ahead and do that because it's going to serve the same purpose because there are so many two-way organizations, groups, and plaintiffs involved in this lawsuit as named plaintiffs that it's still going to serve the same purpose. Now, like I mentioned, the Trump administration through Harmony Dillon actually got to participate during these oral arguments and argue on behalf of striking down PICA. During those arguments, she claimed that the U.S. has a strong interest in ensuring that the Second Amendment is not treated like a second-class right. She stated that she aligns with what Justice Thomas has been saying all along about the Seventh Circuit and how they're treating this like a second-class right and how they've actually got the Second Amendment analysis wrong after Bruen and Heller. So those really are just some highlight takeaways from the oral arguments and some things I think you should know about that kind of developed during those arguments. My impression, again, of this is that this could be a 2-1 win in our favor. However, I think that if this does go our way, I suspect that the Seventh Circuit here will limit the win to just the named plaintiffs, which really would not have a ton of impact on the scope of relief because, as I mentioned, there's so many two-way organizations and plaintiffs involved in this case. But I also think the more concerning thing that could happen is the court here could try to limit the ruling to just apply to AR-15s and magazines. That would not be a full win, but it would still be a pretty big win coming out of the Seventh Circuit. But I could also be completely wrong. The Seventh Circuit has had a very bad track record when it comes to the Second Amendment and these types of issues. And it could be simply business as usual, where they just say, we're going to reverse Judge McGlynn. We essentially don't believe in the Second Amendment. We don't believe that these are protected arms, and we think the state of Illinois can ban these items. I will say no matter what happens in this case at this 3-judge panel level, this is obviously destined at some point to make its way to the en banc panel in the 7th Circuit. There's probably going to be a petition by either side, whoever loses. And eventually this is one of those cases that probably will make its way to the Supreme Court if the Supreme Court does not first take up another, rifle ban or magazine ban case. That's what just happened in the Illinois PICA case. They were arguing from the 7th Circuit. So as we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. As I mentioned, you can also sign up for my legal course. Again, it's going to end Friday night, so you only have a limited time. If you're interested, if you want to sign up for the course, you have a limited time to get in. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.